Hi, my name's Paul Danziger with Danziger De Llano. We're an asbestos mesothelioma firm. We've been representing individuals for over 30 years who've been diagnosed with mesothelioma or asbestos lung cancer. And we've recovered over $2 billion for our clients. Our clients, on an individual case, routinely recover over $1 million. I want to do an update on a recent decision that affects asbestos and mesothelioma clients. In a recent decision, the federal courts in Massachusetts addressed a long-running asbestos case involving Bruce Wright, a career mechanic who worked on multiple truck shops between 1969 and 2013. Mr. Wright and his wife, Louise, claimed that he was exposed to asbestos-containing brakes while servicing Mack trucks during his work for several companies. Mr. Wright was diagnosed with malignant mesothelioma in November 2022, and the couple sued Mack Trucks, alleging negligence, breach of warranty, failure to warn, and defective design. Mack denied liability and moved for summary judgment, arguing that it had eliminated asbestos from its products years before Mr. Wright's alleged exposure began. The court granted summary judgment in favor of Mack Trucks, dismissing all claims. The judge found that Mack removed asbestos from clutches by 1982 and from brakes by 1989, several years before Mr. Wright worked on those components. Evidence suggesting later exposure was speculative and not supported by the records, the court found. A small number of gasket jobs identified in 1986 did not demonstrate a level of exposure sufficient to meet the legal threshold for causation. The court also ruled that Mrs. Wright's loss of consortium claim failed because it depended on her husband's personal injury claim, which had been dismissed. Why it matters to mesothelioma victims and those who are going to file a lawsuit. The decision highlights how courts apply strict proof standards in asbestos litigation, especially regarding exposure timelines and product identification. These rulings serve as an important reminder that asbestos litigation requires deep investigation, expert product tracing, and medical documentation to establish exposure and causation. At Danziger De Llano, we know how quickly asbestos case law evolves, and we keep our clients ahead of it. Our attorneys monitor federal and state court rulings across the country, adapting our litigation strategy to match the latest standards for proving exposure and causation. That proactive approach ensures our clients' cases are built with the most current evidence, expert analysis, and the strongest presentation possible. Families often ask what type of compensation are available in mesothelioma cases. At Danziger De Llano, we help our clients recover money through the asbestos bankruptcy trusts, such as John Manville, Owen Corning, Fireboard, and W.R. Grace. Through settlements with companies, people that us or our team have previously held responsible for asbestos exposure. And lastly, our team will litigate against any active corporations that still deny accountability. Many of our clients will start receiving compensation within 90 days, with additional compensation to follow over the next 18 months. All consultations are free and confidential, and you pay nothing unless we recover for your family. If you or a loved one worked as a mechanic, brake technician, or industrial laborer, or have developed mesothelioma for many other types of asbestos exposure, time matters. At Danziger De Llano, we combine decades of experience with a deep understanding of changing asbestos law to fight for every client's full recovery. Call us at 1-800-996-4000 or visit our website, dandel.com, for a free confidential case review. We've helped thousands of families across the country obtain the compensation that they rightly deserve. Give us a call. Thank you.